Okay, so welcome back everyone to the next session of the UCL InfoSec research seminar. And yeah, today it's my great pleasure to welcome Arianna Trozze, or as I've learned, Trozze, which is apparently the correct Italian pronunciation to satisfy also our Italian audience. And Arianna is a PhD student at our CDT in cybersecurity and works with Bennett Kleinberg and Toby Davis from the Department of Security and Crime Science. And in her research, she focuses on detecting and prosecuting financial crimes involving cryptocurrencies. And yeah, we will see a part of that work today. So Arianna, please take it away.
Great, thank you. So as Philip said, I'm Arianna and I'm a second year student in the CDT for cybersecurity and also associated with the Department of Security and Crime Science. And today I'm going to talk about a recent study that I conducted on factors that explain prosecution outcomes in cryptocurrency-based financial crimes. As Henry warned you guys last week, this is a bit of a divergence from our usual content, but hopefully it'll be interesting for you to get kind of a different legal perspective on these sorts of issues. Generally, I'll keep questions to the end, but if there's some particular legal definition or something that you need, feel free to stop me and I can explain. So, as we're all aware, cryptocurrencies have essentially completely changed the way financial crimes are carried out today. They've been used to commit various crimes, including things like money laundering, hacking, initial coin offering scams, Ponzi schemes, sanctions violations, tax evasion, market manipulation, and a lot of other different types of fraud and financial crime. Enforcement efforts have started against these sorts of crimes, primarily in the US, but they do remain in their early stages, particularly relative to the estimated value of these crimes, which is in the billions of dollars per year. Some scholars have suggested that we should have specific regulation related to virtual currencies, but I would argue that predicate offenses like wire fraud are already useful in prosecuting these crimes. With this in mind, my research seeks to develop a model for successfully prosecuting cryptocurrency-based financial crimes. And a first step in doing this is to determine what has worked so far in these cases. Therefore, in this study, I used publicly available case documents, bivariate analyses, and logistic regressions to explore the role of legal and extra-legal factors in explaining case outcomes. Our aim generally was to kind of figure out what made a prosecution of a cryptocurrency-based financial crime succeed or fail in order to improve future enforcement efforts and resource allocation. This is the first study that we're aware of that looks at factors that explain prosecution outcomes in financial crime empirically, basically at all, let alone in the context of cryptocurrency. So therefore, this study is primarily informed by literature on factors affecting outcomes in various stages of prosecution in other areas of crime, including domestic violence, sexual assault, and drug cases. So in order to conduct this research, we explored cases that have been prosecuted in the US, basically just because more cryptocurrency-based financial crimes have been prosecuted there than anywhere else. In a study of cases up to February 2019, the researchers found that 41% of all cases that have been brought involving cryptocurrencies were in US courts, and the rest were kind of scattered throughout the world. There wasn't anywhere else where the cases were so highly concentrated. So we conducted a search on Westlaw, which is an online legal research database, and it contains the dockets from all US federal court cases and all of the documents that are filed in those dockets. A court docket is basically just a list of all the documents that are filed throughout the life of a case, and it records key events like arrests and hearings and trials and the like. These documents include things like court transcripts, motions, memoranda of law, evidence, and a variety of other types of documents. So we conducted a search of all of the US federal cases for cryptocurrency, Bitcoin, and virtual currencies, and then collected all cases, both civil and criminal, where a case had been decided before the 1st of May 2020, and which involved a financial crime offense and in which some sort of cryptocurrency featured. We included the following specific financial crimes, so fraud, bribery and corruption, insider dealing and market abuse, money laundering, and financial or trade sanctions, and antitrust violations. Although civil and criminal cases generally differ in their standards of proof and overall goal, We include both because they're likely to be broadly equivalent in the terms that we are examining in this study. That being said, we did specifically exclude in rem civil asset forfeiture cases from the study. And these kinds of cases are basically enforcement cases against a particular asset that's been involved in some sort of criminal conduct. Then, after obtaining the data from Westlaw, we cross-referenced the list with press releases from all US government enforcement agencies that handle financial crime in order to ensure that we captured the entire population of cryptocurrency-based financial crime cases. So this includes the Department of Justice, the Securities and Exchange Commission, the Commodity Futures Trading Commission, Federal Trade Commission, the IRS, the Department of Treasury, and the Financial Industry Regulatory Authority. We then cross-referenced our sample with the cases that were studied in that study that I mentioned earlier that looked at all the cryptocurrency cases globally up to February 2019. We added cases from these additional sources that met our inclusion criteria in order to reach our ultimate data set. So then once we had the cases, we looked at dockets and documents they contained using Westlaw, using PACER, which is the US government's public access to court electronic records service, and Court Listener, which is a repository provided by the Free Law Project, which is a US registered nonprofit. We extracted various variables based on defendant, case, and outcome characteristics. In terms of case outcomes, we looked at how a case was disposed, so whether or not it was voluntarily dismissed, settled, went to trial, ended in a summary or default judgment, or was resolved by guilty plea. For criminal cases, we looked at whether or not the case resulted in a custodial or non-custodial sentence, and for civil cases, we extracted the monetary penalty. We didn't look at monetary penalties for criminal cases since we decided to exclude the in rem civil asset forfeiture cases, which tend to run parallel to criminal cases and effectively enforce the criminal monetary penalty in those cases. In terms of the specific offense characteristics that we looked at, we examined the number of charges filed. This was shown to impact case outcomes in previous studies and other areas of law. For criminal cases, we specifically looked at whether or not wire fraud was charged, basically because I think, and other scholars agree, that it's the easiest existing charge to use for these types of crimes. Basically, wire fraud is using some sort of telecommunications or the internet to conduct some form of financial fraud. So basically, if someone calls you up to plan a financial crime, then they've committed wire fraud. Finally, we were interested in whether or not Bitcoin specifically was involved in any way in the alleged crime, or whether or not it was another cryptocurrency entirely in the alleged misconduct. We looked at defendant characteristics as well, as these had been shown to play a role in case outcomes in other areas of law. We specifically looked at the number of defendants, as previously scholars had argued that joinders in criminal cases unfairly prejudiced defendants. And we also looked at whether or not a corporate defendant was involved. And the reason we looked at this is because of the trend in the US based on the Yates memo, which was published in 2015, that kind of affirms the US Department of Justice's commitment to holding individuals accountable for corporate wrongdoing. So basically, if a corporation accepts responsibility for criminal actions taken on behalf of one of its employees, if that individual is charged with the same misconduct, they'd intuitively be more likely to be found guilty because the corporation had already said that the conduct had occurred and they'd already taken responsibility for it. And we've seen this time and time again in various financial crime cases in the US. And then finally, we extracted data about the evidence that was filed in these cases, as various scholars have shown that the impact of witness and forensic evidence on case outcomes. We looked generally at whether or not there was any witness evidence that was filed at all, and whether or not the forensic evidence that was filed was quantitative or qualitative in nature. Then finally, we looked at whether or not any additional evidence was filed after the charging document or the complaint was filed. So our initial search brought back a promising 483 cases, but a ton of these were duplicates or didn't meet our search criteria. We basically used Westlaw summaries and press releases to get rid of the cases that didn't involve a financial crime offense, the in rem civil asset forfeiture cases, cases which hadn't been concluded by the 1st of May 2020, cases where too many documents were sealed, cases that didn't involve a government plaintiff, and cases that were currently on appeal because those effectively also hadn't been fully resolved. Ultimately, that meant getting rid of 404 cases. After cross-referencing with the paper I mentioned and the press releases, we were left with an initial set of 50 cases, and that's the set that we used to assess intercoder reliability, which I will talk about in a second. Then we conducted some more detailed data extraction and found that a lot of the cases hadn't actually been fully resolved and that we ended up having to exclude them, and that left us with only 37 cases. It's a really small data set, but it does constitute the entire universe of cases that met our search criteria. And one of the primary issues that we did run into was that a lot of cases that should have been resolved by the 1st of May were delayed due to COVID because all the courts were closed. And a lot of these cases just weren't the priority at that time. Ultimately, of our final set, 10 of the cases came from press releases, 8 from that previous study that we mentioned, and 18 from our original Westlaw search. The final case was a criminal case that was parallel to a civil one, which had come up in our original search and which we kind of discovered when we were reviewing the documents for that case. Then we had 2 individuals who have prior legal knowledge and work in the legal industry, each code the same subset of 10 cases out of that 50. They were randomly selected from that initial population of 50 cases. We provided them with instructions in narrative form as well as in the form of a flowchart. I know this looks crazy, but it has all the instructions there, the specific questions they were meant to ask themselves based on the particular documents in order to code the data. Once they coded that, we calculated FLICE's kappa. We got a kappa score of 0.791, which was highly significant and signified a high level of agreement among the coders. And now on to the results. This chart shows the coding frequencies for all of the cases that we studied. As you can see, most of the cases were resolved by guilty plea, summary, or default judgment. Only one case was resolved in favor of the defendant and was voluntarily dismissed. In the rest of the cases, the US government won, which is, as we'll hear later, pretty normal in the US criminal justice system. Very few of the cases went to trial, which is in line with the trend in financial crime cases, and even fewer actually went through a jury trial versus a bench trial. As you can see here, most of the cases involved 2, 3, 4, or 5 charges. There were a lot of different kinds of charges in the data set, and these included different types of fraud, failure to register either as securities exchanges, as a broker-dealer, as a money transmitting business, etc., off-exchange transactions, some wire fraud, money laundering, general reporting violations. There was quite a lot of market manipulation, and then just sort of general aiding and abetting and conspiracy violations of all of those aforementioned offenses. To a lesser extent, the charges involved narcotics and firearm violations and extortion and tax violations. We were actually pretty surprised that wire fraud was only charged in the end 22% of the time in criminal cases, and we saw no Foreign Corrupt Practices Act charges. So the FCPA outlaws bribing a foreign government official, which intuitively makes sense that people would be using cryptocurrencies to do this, but I guess they haven't been caught yet if they are, or perhaps there just wasn't enough evidence to charge them. Almost all of the cases that we reviewed included Bitcoin in some capacity, so 70% of the cases did, which was slightly surprising, though this was more evenly split for civil cases where it was about half that used Bitcoin, half that involved another cryptocurrency, primarily a series of sort of random initial coin offering token scams. I haven't included the chart here, but we also looked at civil and criminal cases separately, and almost all of the criminal cases had only one defendant, so 94% of them did. Individual defendants versus corporate defendants, and just over half of them had only one defendant. Comparatively, 79% of civil cases had 2, 3, 4, or 5 defendants, and 80% included a corporate defendant. In terms of evidence, we saw qualitative evidence used much more frequently as proof of these crimes than quantitative evidence. This means things like screenshots of marketing materials, PowerPoints, emails, tweets, and the like. Furthermore, the quantitative evidence that we did see was really, really basic, basically just bank statements rather than any sort of complex financial analysis or blockchain evidence or anything like that. Additional evidence was only filed in half of the cases after the initial complaint or charging document, and witness evidence was present in just over half of cases. So following on from previous studies that look at explaining prosecution outcomes in other areas of law, in order to understand how our independent variables were associated with case outcomes, we used Fisher's exact test. Some of our counts were too small, as you can expect from the small sample size for a chi-squared test. In addition to these associations, we were also interested in the predictive value of these different variables and characteristics in relation to case outcomes. So we explored this using logistic regression. So for the set of all cases, civil and criminal, charges and disposition, cryptocurrency and disposition, number of defendants and disposition, and the type of defendant and disposition were significantly associated with one another. For criminal cases, there was an association between witness evidence and disposition and forensic evidence and disposition. And for civil cases, there was an association between the number of charges and the disposition of the case. Using the results of these Fisher's exact tests that you see here, we examined the direction of these associations using contingency tables. We obviously can't say anything from these about the simultaneous effects of the variables, the size of these effects, but I'll talk about the logistic regressions where we explore this in a second. So for our entire population, the most common number of counts charged, 2 through 5, were most often resolved by settlement, guilty plea, and summary or default judgment. And then cases involving the most common number of defendants in our population, so 2 through 5, followed the same trend. Cases involving Bitcoin were more often resolved by guilty plea than any of the other modes of disposition, and cases involving an individual defendant only, rather than a corporate one, were also most often resolved by guilty plea. Cases that had a corporate defendant were most often resolved by settlement or summary or default judgment. For criminal cases, all the cases that didn't have any witness or forensic evidence were resolved by guilty plea. Those with witness evidence or forensic evidence were disposed by guilty plea about half the time, and jury trial the other half the time. So again, following prior research on factors associated with case outcomes, we use multinomial logistic regression to further analyze our data. We initially wanted to explore the influence of all of our independent variables on the disposition of cases. However, witness evidence and forensic evidence exhibited collinearity, so we ended up having to exclude witness evidence from our models. In many iterations, we also excluded the single case that was voluntarily dismissed because it was the only case that was coded that way. Using the original coding scheme, the number of charges, cryptocurrency used, number of defendants, type of forensic evidence, and presence of additional evidence were not significant predictors of the disposition for all cases. We therefore looked at building an alternative version of this model by aggregating categories of both the independent and dependent variables. We did this in part to mitigate the relatively low number of cases in the various categories. As well as what we're presenting here in this slide, we also tried a number of alternate aggregations. The findings of those were broadly consistent with what's reported in this presentation, though. In the final model, the results of which are shown here, we used a multinomial logistic regression in which the dependent variable, the disposition of the case, had 3 specific levels, so jury or bench trial, summary or default judgment, and guilty plea or settlement. In this model, the number of charges was also aggregated into 2 separate categories, low number of charges and a high number of charges. And finally, we aggregated the number of defendants into 2 categories, 1 defendant and more than 1 defendant. When controlling for the other variables and using the case being resolved by guilty plea or settlement as a reference category, the presence of an individual rather than a corporate defendant was the only significant predictor of disposition. It showed a significant association with cases being resolved by summary or default judgment. So this corresponds to a multiplicative change in the odds of a case being resolved by summary or default judgment by a factor of 0.014. That is, when there's only an individual defendant and no corporate defendants, the odds of a case being resolved by summary or default judgment relative to a guilty plea or settlement decreased by 98.6%. For the sake of transparency, we note that some of the variables in the above model have a standard error of 0, but aren't significant. We expect that this is just because of the small population size and resulting failure to converge and some 0 counts for some of the variable combinations. We also note that when we use trial, the first category, as the reference category, instead of guilty plea or settlement, additional evidence becomes a significant predictor of a case being resolved by a summary or default judgment, but the odds ratio becomes gigantic and explodes. So we acknowledge that changing the reference category really shouldn't affect the level of significance, and expect that this is a similar issue just with the small population size. So all of that being said, with all of those caveats, we still decide to interpret the results of this model, but we acknowledge that it isn't a particularly stable model and the results are subject to some level of uncertainty. So in summary, our main findings are as follows. The number of charges, cryptocurrency use, number of defendants, and nature of defendants were each associated with the mode of disposition for all cases. Witness and forensic evidence were associated with the mode of disposition for criminal cases, and the number of charges was associated with the disposition of civil cases. And as I mentioned recently, when controlling for other independent variables, the presence of an individual rather than a corporate defendant made a case less likely to be resolved by summary or default judgment. As I mentioned, the original coding model didn't yield significant results. This could be due to the small population of cases, but another reason for this could just be because these crimes have only just started being prosecuted and there haven't really been firmly established norms in their treatment or precedent established yet. So this could lead to low levels of predictability among the different variables. So our finding that 83% of all criminal cases in the study were resolved by guilty plea is consistent with previous research that 97% of criminal convictions in the US are obtained by guilty plea. Given that studies have shown that about half of defendants who plead guilty in the US are actually innocent, this is kind of an issue. There's generally a lot of criticism in the literature that prosecutors in the US are basically just trying to rack up convictions rather than positioning their practice around seeking justice and truth. This is particularly a criticism in the area of so-called white-collar crimes. The government basically always wins these cases, and this is also consistent with our research and the fact that only one case was voluntarily dismissed. So these trends that we see in other areas of financial crime seem to hold for cryptocurrency-based financial crime. Because this is a new area of case law, prosecutors have kind of a further incentive to win the cases. So they'll likely want to choose cases that they know they're going to win and resolve cases as efficiently as possible in order to develop precedent in their favor. That being said, a lot of the instances of guilty pleas are likely due to resource constraints on both sides of the fence. So from the prosecutor's side, they're going to go for sort of the surefire cases that have a higher chance of securing a guilty plea to avoid having to spend lots of time and money preparing for a trial. And then on the other side, a defendant might also not have the means to pay lawyers the $1,000 or so per hour and spend thousands and thousands of hours preparing for a trial. Overcharging and sentencing guidelines provide a further incentive for defendants to plead guilty. It's often just too risky for a defendant to exercise their right to trial by jury. If every additional charge carries a 20-year maximum sentence, for example, so I think that's the sentence for wire fraud, they've got 2 to 5 charges against them. It might be better to negotiate down to 1 charge and get a super reduced sentence in exchange for a guilty plea. We definitely saw evidence of overcharging in the cases we studied, and particularly we saw evidence of horizontal overcharging, which basically involves adding lots and lots of charges to up the minimum sentence and essentially inspire the defendant to plead guilty. We didn't quantify this effect, but only 14% of all the cases charged a single count, and 3 of the cases had 11 or more counts charged. In a lot of the instances as well, particularly in criminal cases, prosecutors filed a lot of superseding indictments. that basically just kept piling on charges, and then these cases were later resolved by a guilty plea. Another example of this is that in a lot of cases, prosecutors would charge, for example, several counts of money laundering for basically the same conduct. And then they also would charge conspiracy to commit money laundering. And then if there was more than one defendant, they also tended to charge the other defendant with aiding and abetting the first defendant in committing the same offense that they were already being charged for, just to kind of trump up the charges and again, get that guilty plea and get things resolved quickly in their favor. Prosecutors can get away with this because they only have to show probable cause for a charge. They don't actually have to have the evidence for it to prove it beyond a reasonable doubt then and there. We don't quantify this effect in the research, but preliminary observations do suggest that future research on the strength of evidence and the incidence of overcharging in cryptocurrency-based financial crimes might be pertinent. In contrast, we don't see any evidence of vertical overcharging really, which involves charging a harsher crime when really a lower level charge is more appropriate. So charging a felony when it really should be a misdemeanor. While a lot of the charges that we did see were expected, so for example, you see in the news a lot about failure to register as a money transmitting business and money laundering charges with cryptocurrency-based financial crime. It was surprising that wire fraud was charged a lot less commonly than we expected, so only in 22% of cases. We anticipated that it would be charged much more just because in basically all other financial crime cases, prosecutors just tend to add in a couple extra counts of wire fraud, basically for good measure, just because it's something that's pretty easy to prove and adds quite a bit to the minimum sentence. As I mentioned earlier, we also didn't see any Foreign Corrupt Practices Act charges or sanctions violations charges, which was surprising, particularly given that other researchers have suggested that this kind of conduct is occurring. Although recently, in the past couple of days, there has been a sanctions violation case that has been brought in the US involving North Korean sanctions violations. But that obviously was not included in the study as it was only a couple of days ago. Considering the media attention around narcotics crimes involving cryptocurrencies and then the subsequent use of cryptocurrencies to launder these proceeds, the narcotics charges in our population were actually a lot rarer than we expected, though we will note that a couple of cases involving these charges are still ongoing and had tons of defendants. So it could just be that those cases take a bit longer to get resolved. And many cases in general, even pretty straightforward financial crime cases, do take several years to go through the justice system. Finally, only one case that was in our study involved tax evasion using cryptocurrencies, and it was a pretty low value case. I think the amount of tax owed was in the low hundreds of thousands of dollars, which is a lot of money to me, but in the grand scheme of tax evasion isn't really that much. And this is kind of surprising because the US estimates that it loses between 40 and $70 billion from cryptocurrency tax avoidance per year. I suspect this is a kind of generous estimate on their side. They don't say really what it's based off of. And as Antonis and Henry will know from our systematic lit review, generally estimating the impact of these kinds of crimes is pretty difficult. But it's still surprising that there weren't more cases charged involving tax evasion. As I mentioned earlier, basically all of the cases involved Bitcoin in some capacity, and somewhat surprisingly, pretty much none of the other cases involved other popular cryptocurrencies. There has been some research that has indicated that a lot of crimes do involve Bitcoin versus other cryptocurrencies, but my suspicion is that it's just, this is what the prosecutors and investigators are kind of looking out for. These are the people who are getting caught. We know, and researchers have shown that other cryptocurrencies are being used to commit these crimes as well. And I would suspect that a sophisticated criminal would probably not use Bitcoin to commit these kinds of crimes. So they are the ones that end up getting caught. The results of our study in terms of defendant characteristics are generally consistent with prior research that the existence of co-defendants didn't actually impact the chances of conviction. But Still, despite the aggregate results of the study, intuitively on a specific case level, there could still be an impact, which we didn't obviously quantify. So for example, if one defendant pleads guilty and then testifies against the other one, and that just builds up more evidence against them. So naturally, it could potentially increase the chances of conviction. None of the cases involving 2 to 5 defendants in our population of cases went to trial, but they were slightly more often resolved by settlement than guilty plea or summary judgment. There might have been pressure for another defendant to settle a civil case or plead guilty in a criminal case once one of the other defendants had done so. But again, we haven't really looked into that yet, as this was kind of just an initial study to get a baseline of things and figure out what kind of the interesting questions were to explore in the future. We found that the presence of an individual rather than a corporate defendant made a case less likely to be resolved by summary or default judgment. As I mentioned, companies generally require cooperation from their employees, so it's less likely that they would be able to kind of disappear and avoid facing their charges, which would result in a summary or default judgment. It's worth noting here, though, that these cases are somewhat different than normal, quote unquote, normal financial crime cases, because the corporate defendants in these cases tend to be small companies that are effectively synonymous with the person who runs them. So this could also be related. Finally, contrary to our expectation and previous research that it would primarily be legal factors that played a predictive role in our population of cases, in the end, it was this extra legal defendant characteristic that explained case outcomes when controlling for the legal factors. As I mentioned before, the quantitative evidence that we saw was really basic, and there was no complex financial analysis or blockchain evidence. Increasingly, though, in private cases, parties are looking to blockchain evidence. So for example, there was a recent case in the UK commercial court where the claimant employed chain analysis to show that coins have been stolen from his account and sent to another one. This evidence was deemed admissible, but there are some questions about the admissibility of blockchain evidence in various jurisdictions. So for example, in 2 recent Chinese cases, the court issued rulings that allowed for blockchain evidence to be used. And then similarly, in Vermont in the US, they have a blockchain enabling act, which allows blockchain evidence to be admitted in state court. But generally in the US, the debate remains open about the admissibility of blockchain evidence, specifically whether or not it's considered hearsay. So essentially, if the US courts decide that blockchain evidence is computer generated, then it's admissible. But if they find that it's human generated, since it's quote unquote created by individuals who are conducting transactions, which is the view that some judges are taking, then it's not admissible. I personally would count it as computer generated, but again, that's up for the courts to decide. Though there is kind of another way that you could maybe get around that if it's deemed inadmissible, and that would be to admit it as a business record under the federal rules of evidence. Finally, there's kind of just the general issue of judges and juries' familiarity with blockchain and their ability to come to decisions primarily using blockchain evidence. And this is an area that I plan to do further research on in the future. So stay tuned for that, but for now it remains an open question. As I mentioned, I wasn't really able to dig as deeply into witness evidence and its impact as I would have liked. That being said, it's worth mentioning that if blockchain evidence were to be admitted, expert witness testimony would probably be really important in validating blockchain evidence and particularly explaining it to a jury so that they were able to come to decisions on it. Finally, we found that additional evidence was only filed in about half of the cases that we looked at. This could be because there really wasn't any need for it. The prosecutors had a basically unbeatable case from the beginning. And I think this was probably the case in some of the initial coin offering scam cases. They were just very obviously scams. However, it could also be related to that famous overcharging in some instances. Prosecutors may not have actually had any additional evidence, but they just could have added extra counts in order to inspire a guilty plea earlier before they were actually required to prove anything. So in that sense, it is still unclear how many of the defendants in these cases were actually guilty or whether or not it just was too big of a risk not to plead guilty. And given the high incidence of false guilty pleas in US criminal cases in general, it is reasonable to assume that the same could be happening here, and more research is needed in that regard. This research suffered from a variety of limitations, some of which I've already mentioned: the small population size, the impact of coronavirus. I think that's probably impacting a lot of people's research right now. Furthermore, we only looked at US cases because that is, even this small population is still bigger than the population of cases anywhere else at this time. And we did look at cases in various federal courts and treated them as the same, even though there have been previous studies that have found disparities in the treatment of cases across the country. A jury in Texas behaves very differently from a jury in New York City, for example. So these kinds of issues do play into case outcomes and have been shown to do so in other studies in different areas of law. We also extracted pretty basic data from our cases, which could be seen as an oversimplification. But again, basically our aim was just to get a baseline of factors that were associated with the successful prosecution of these types of crimes, with the aim of kind of building on this in future research. Finally, we analyzed civil and criminal cases together, and we didn't distinguish between things like expert and fact witness testimony and some other things. So in terms of future research, it would be useful to look in more granularity at some of the specific combinations of charges, for example, and burdens of proof for these charges. Could look at other factors that might influence case outcomes, such as the quality and type of counsel, victim participation, or defendant income, which we didn't look at. It also would be useful to maybe, which I've considered doing, expand the population of cases to all financial crimes, just so that there is some more predictive value potentially in the variables. And the rest of my sort of PhD research will further explore, as I mentioned, blockchain forensic evidence, and basically how we can use that in court, make it admissible, make it palatable to a jury, how we can automate collection of this kind of evidence, and also the costs and benefits of using this kind of evidence for the US government. All right, that's all I have for today. Thank you all for listening, and let me know if you have any questions. And if you think of anything afterwards, I put my email there, so feel free to reach out if something comes to you later on.
Okay, cool. Great. Thanks a lot, Arianna. Let me briefly stop the recording and then we'll open the floor for questions.
Okay.